Hi there, Kate Medine here, endeavoring to discuss confidentiality and privileged communication in the counseling relationship. My references are a article, Mental Health Counselors' Perceptions of Ethical Behaviors, and that's by Levitt, Carlisle, and Newkrug. Also, I used the Ohio Administrative Code taken from the codes.ohio.gov website, and our textbook, Ethical, Legal, and Professional Issues in Counseling by Remley and Herlihy. So the ACA Code of Ethics Section B is entirely dedicated to the topic of confidentiality and privacy. The overarching theme of that section revolves around a counselor's respect for privacy and the protection of confidential information. The section also outlines the counselor's responsibility to properly inform clients of the limitations of confidentiality while maintaining an awareness to cultural meanings and differing views concerning the disclosure of information. According to our text, and I quote, privileged communication means a judge cannot order information that has been recognized by law as privileged to be revealed in court. So privileged information is concerned with a citizen's right to privacy, and this is constitutionally guaranteed to us in the Fourth Amendment that prohibits government searches without warrants. However, this is not an absolute right, and this is important, right? Because when the interests of society outweigh an individual's right to privacy, privileged information, it can be compromised for the benefit of the societal structure. So it's important to note that statutes regarding privileged information between a counselor and a client vary from state to state. Studies related to confidentiality and privilege in the counseling relationship have revealed an overarching attitude that although confidentiality is important, privilege in the counseling relationship is not necessarily so. The basic difference between confidentiality and privilege in the counseling relationship is that confidentiality is the ethical duty of the counselor to maintain, while client privilege is the client's right to keep disclosed information out of legal proceedings. In both circumstances, though, the counselor has to remember that confidentiality and privilege rights belong to the client and not the counselor. So group counseling and family and couples counseling would be two different examples of limitations of confidentiality. So counselors cannot make guarantees of absolute confidentiality in a group context, and definitely cannot make a guarantee of confidentiality among group members or people that are not bound by the same professional standards as we are. The ACA Code of Ethics addresses the issue of group counseling in Section B4A, which requires counselors to clearly explain the importance and parameters of confidentiality for the specific group. So we have to be very clear at the get-go when we're involved in group counseling of communicating the boundaries, expectations, and procedures. And also we need to ensure that we are not guaranteeing confidentiality when it comes to group counseling. Couples and family counseling can be particularly complicated, especially when it comes to family secrets. So a few things to consider are, according to the ethical code of the International Association of Marriage and Family Counselors, information shared in an individual counseling session cannot be shared with other family members without the client's permission. However, under general legal principles, the client's privilege is waived if there is a third party present when the information is being disclosed. So privilege laws differ from state to state, and court decisions seem to be widely split on whether privilege that would otherwise exist by statute should be extended to married couples. The ACA Ethical Code B1C states, and I quote, that counselors must protect confidential information and disclose only with appropriate consent or sound legal or ethical justification. So when navigating the counsel of couples and families, counselors have to be very clear in defining how confidentiality will be handled, the limitations of confidentiality, and they should always obtain a written and signed agreement of the understanding among all parties involved. So according to the article, Mental Health Counselors' Perceptions of Ethical Behavior, relaxed or unclear boundaries of counselors can lead to misunderstandings or potential harm of the clients. So clients often follow the lead of the counselor regarding negotiation and management around the nature of counseling. So we need to be mindful of that. The Ohio state law basically states that counselors have the primary obligation to protect the client's rights of confidentiality. Confidential information can only be revealed to others when counselors have obtained informed consent from their client, except in the circumstances in which a failure to disclose that information violates other laws or could result in a clear danger to clients or others. So it does appear that overall, counselor client privilege is supported in the state of Ohio. Thank you.